Hello, everyone. Welcome to the Teske Brief. I'm Judge Stephen Teske, retired, and this is episode 11. It's titled Expert Opinion versus Legal Analysis. And, what really matters in use of force cases, since we are about to close out our series on the siege of Minneapolis, I thought I would end on this note, giving that there's been so much out there on social media, on news stories about what has occurred involving Renee Good and Alex Preddy in terms of how that went down. I've seen folks talk on both sides. Unfortunately, I have seen some videos where some persons who claim to be experts, and they probably are. They seem like they have sufficient law enforcement experience, and they've testified before. At least they state they have. But my concern is that some of these have already drawn a conclusion. There's a difference between that and a legal analysis, or let's just say, I've seen some experts, former FBI and others, but they've testified in the past, but they don't draw a conclusion. They're very careful about that. And what they share is just some analysis, what it could be. It could be this, it could be that. It depends on these factors. And that's okay. That's okay. But let's pause for a moment and let's separate myth from law. And the myth, is this. If someone claims decades of law enforcement training and global experience, then their interpretation of a use of force incident is legally authoritative. But we have to keep in mind, and here's what the law says, that expert opinion in use of force cases, whether offered in media commentary or in court, must be rooted in neutral, legally relevant analysis of all the material facts, not selective assertions that fit a preferred narrative. And what I mean by preferred narrative, if they're already jumping to a conclusion that it was a justified shooting just based upon looking at the videos, you had to be careful about that, okay? And you'll see why in a moment. I'm going to show you a video of an expert who specially testifies in use of force and firearm training, has been doing it for a couple of decades, okay? And to give you an idea of what goes into being and testifying as an expert in use of force. But a true expert does not choose which facts support one side and ignore others, right? A true expert presents the full picture, evaluates competing interpretations, and ties factual findings to current legal standards, including what the Constitution actually says or how it should be applied. Now, I want to say this, for those that I've seen who've drawn conclusions, quite frankly, my first thought is, I wonder if they tend to testify all the time in defense of police officers, right? Okay. Because then to be asked to do a video is an opportunity for them to show the ICE agents in this case, hey, if they happen to end up needing lawyers, hey, why don't we get this guy? Okay, seems like he knows what he's talking about, and he's already said that this was a justified shooting. Of course, the problem is that tape, that video or that newscast where he's already come to that conclusion is going to be used against him, by the way, in cross-examination. I'll explain that later. But when someone is offered as an expert witness in a civil or criminal case involving alleged constitutional violations, judges do not admit self-described expertise alone. So this is what they evaluate. Number one, whether the proffered opinion is based upon established legal standards like objective reasonableness rather than personal heuristics, okay? Whether the opinion relies on complete evidence rather than selective impressions, or thirdly, whether the opinion is the product of reliable methodology and not personal bias. And then another one is whether the expert will help the trier of fact, that is the jury, understand legally significant points rather than simply advocate one side's narrative. So I promised you a video, and I think this is a good time to show it. So let's hear from this expert. As I said, he's testified on use of force cases for a couple decades or more, and has been through the test of being cross-examined by prosecutors and defense attorneys, depending upon which side his expert analysis may come down on. Is it in defense of the police officer, or is it not a justified shooting? Once you hear what goes into an expert on the use of force and what he does before delivering an opinion, I think you'll question those self-proclaimed experts on social media who have already judged the case when it was impossible for them to have acquired all the evidence. I mean, my goodness, all there were videos for them to rely on at that point in time anyway. But listen carefully to this, okay?
What does a use of force expert witness actually do? Most people assume it means testifying in court. That is only a small part of it. My name is Josh Logan. I serve as an expert witness in cases involving firearms, self-defense, law enforcement use of force, and high-stress decision-making. I bring over 17 years of combined military and law enforcement experience, and I'm currently in my 20th year of teaching firearms and use of force principles to professionals across the country. My work begins long before anyone walks into a courtroom. When I am retained on a case, I conduct a comprehensive and objective review of all available evidence. That includes body-worn camera footage, surveillance video, dispatch recordings, written reports, photographs, scene diagrams, training records, and when available, forensic data. I analyze each case through three primary lenses. First is human performance under stress. As a force science certified analyst, I evaluate perception, reaction time, attentional focus, memory formation, and physiological limitations during rapidly evolving events. Critical incidents do not happen in slow motion. They unfold in fractions of a second. Understanding what a person can realistically perceive and process in that moment is essential. Second is training standards and accepted practices. Because I've spent 2 decades teaching firearms and use of force at a national level, I evaluate whether the actions taken were consistent with generally accepted training principles and professional standards, not idealized standards. Real-world standards that reflect how officers and armed citizens are actually trained. Third is objective reasonableness. Every force case ultimately centers on whether the decision was reasonable based on the totality of the circumstances at that moment. Not hindsight, not frame-by-frame video review, but a reasonable person would have perceived and decided in real time. My role is not to advocate. My role is to analyze. Sometimes my findings support the retaining party. Sometimes they do not. Credibility matters more than conclusions. When my review is complete, I provide a structured written report that breaks down complex dynamics into language that judges and juries can clearly understand. If the case proceeds to deposition or trial, I provide direct, evidence-based testimony explaining the science, the training standards, and the context of the decision-making. One of the most misunderstood aspects of force cases is context. Force decisions happen under time compression. These are variables that must be considered: distance, movement, lighting conditions, background threats, cognitive load, reactionary gaps, and weapon mechanics. Statistics do not decide these cases. Context does.
All right. So when you see a social media post that begins with a long recitation of training history, followed by interpretations like the driver had means, opportunity, ability, and intent, and the ICE agent was justified in deadly force because the driver reversed, then accelerated. Well, understand this. Those are blog style opinions, not legal analysis tied to constitutional law. They ignore key issues that courts must consider under modern law, including whether the officer's actions created or escalated the danger, whether a reasonable officer would perceive imminent threat given all the facts, and whether competing evidence undercuts the asserted narrative. Now, keep in mind, during the video, I cut in, right? Because that video was done before the Barnes and Felix United States Supreme Court case decided just last year. And so I had to step in, and when he said the totality of the circumstances, but then he said in that moment, well, that's the old moment of threat. The totality of circumstances no longer is in that moment, that split decision at the moment of pulling that trigger, let's say. Okay. So I had to step in and clarify that and say, because I could tell you this expert is now having to redo that video. Okay. Because it's no longer in the totality of circumstances of that moment. Now, a court would not simply adopt the witness's personal heuristic, like the means, opportunity, ability, intent, as if it were some legal standard, right? So courts apply the Supreme Court's totality of circumstances framework, which, as I said, focuses on objective reasonableness and prohibits narrowing the inquiry to a single moment or selective facts, hence why I broke into that video. I didn't want y'all to be confused after everything we've learned about what the law is today. Jurors are expressly instructed that they cannot weigh only on that last second of an encounter without context. Again, this is just a refresher. But they must consider everything the officer knew, did, and could have done differently. Now, what makes this dangerous, especially when someone presents a biased viewpoint as an expert, is that non-lawyers may assume any credential automatically qualifies the opinion as legally sound. But legal expertise requires, number one, accurate understanding of constitutional use of force doctrine, okay, application of Supreme Court precedent, not tactical training mnemonics, okay, recognition of disputed facts instead of assumptions, and neutrality, not advocacy. Like the experts who are seeking to take advantage, or at least they think they're taking advantage of doing a video and offering an opinion that it was a justified shooting in the case of Renee Good and Alex Preddy, probably most likely because that's all the work they get is in defending police officers. But the problem is a prosecutor, let's say, who's prosecuting a police officer, or the plaintiff's attorney for the Renee Good or Alex Preddy family is going to get to cross-examine that expert and is going to present that video and say, how could you have rendered this decision, this expert decision, before you even received any incident reports, interviewed anybody, done any ballistics analysis, okay, and so forth and so on. You get my point. Well, go back to the video and what that expert said that he goes through, okay, before he renders any written report. And he was very clear to say, sometimes I find it's not a justified shooting, sometimes that I do. I have to wait for the conclusion based upon the evidence that I've been able to gather. So an expert who ignores these elements or whose public postings show political or personal bias can do more harm than good when the goal is to educate the public about the law. So when you hear, because I train police worldwide, here's the legal conclusion, understand this. Having training experience does not make someone a legal experience on constitutional use of force standards. The law requires contextual. Remember what he said, that expert, okay? It's not based, these decisions are not just, they're not based on statistics, it's based upon context. And the law requires contextual, evidence-based, neutral analysis, not selective interpretations. Okay. Anyway, I thought this would be the best way to conclude the Siege on Minneapolis series is to dot that I, or maybe cross the T, because it's been kind of bothering me about what some people have been saying out there, and I think it's just premature at this point. That doesn't mean that they may not, in the end, come out to be correct, but this is not the way to do it. It's about process, because an expert's credibility is based upon how the expert goes about analyzing the evidence, but you have to get the evidence first. All right, ladies and gentlemen, That's not opinion. That's how the law works, and this is the Teske brief. That's what we try to do, separate the law from the myth. Until next time, everyone take care. Please be safe.